This is a surprising ruling, as family law matters are generally left to member states by the European Union. This includes Poland. Now the European Union Court of Justice has decided otherwise. EU citizenship. A member state is obliged to recognise the marriage of two EU citizens of the same sex legally contracted in another member state where they exercise their right to freedom of movement and residence. This case concerns two Polish citizens who were married in Germany. When they wanted to have their marriage certificate transcribed at a Polish registry office, they were refused. Rightly so. The law on civil status records is clear. Specifically, Article 83 states that a marriage outside the territory of the Republic of Poland by a Polish citizen is concluded in accordance with Polish law. If a marriage is to be concluded outside the Republic of Poland by a Polish citizen, or a foreigner who, in accordance with the provisions of the Act of February 4, 2011, Private International Law, the possibility of entering into a marriage is assessed on the basis of Polish law. They may receive a written certificate in paper form stating that, in accordance with Polish law, they may enter into the marriage. Pursuant to Article 107 of the same Act, the head of the registry office shall refuse to make a transcription if 1. The document is not recognised as a civil status document in the country of issue, or does not have the force of an official document, or was not issued by a competent authority, or raises doubts as to its authenticity, or confirms an event other than birth, marriage, or death. 2. The foreign document was created as a result of transcription in a country other than the country of the event. 3. The transcription will be contrary to the fundamental principles of the legal order in the Republic of Poland. Above all, there is also the Constitution, the fundamental law, which clearly states, Article 18, marriage as a union between a woman and a man, family, motherhood and parenthood are under the protection and care of the Republic of Poland. On the 25th of November, the Court of Justice of the European Union ruled that an EU member state is obliged to recognise a same-sex marriage legally contracted in another EU country, even if the law of that country does not recognise such unions. Sorry, Poland, you have to recognise our marriage. What now? How can we reconcile the clear legal acts of a member state of the Union, that is Poland, with the ruling of the CJEU, which does not constitute law? If someone asks me what to do with a ruling of the European Court of Human Rights, or what to do with a ruling of the Court of Justice of the European Union, there is only one answer. It must be enforced. Minister of Justice, Waldemar Żurek, already admits that before implementation, the law will have to be adapted. We will have to implement this ruling in some way, but I think this is the first step. We should simply educate people. Some lawyers argue that the Constitution does indeed provide for the protection of the family, men and women, but says nothing explicitly about same-sex marriages. Prime Minister Donald Tusk agrees with him. This is Europe. We will, of course, respect the rulings of the European courts, including on this issue. They apply to all those who live in other European countries, and when they come to Poland, we will want to treat them with full respect, but also in accordance with Polish law. And we see Donald Tusk, who is actually enthusiastic about it. It is against the Constitution, it is against Polish law, but we are to respect it. The Polish People's Party, one of the members of Tusk's coalition government, opposes the idea. First of all, we have a clear provision in Article 18 of the Constitution of the Republic of Poland defining what marriage is. We also have the relevant provisions in the Family Code and the Guardianship Code on this matter. Above the Constitution and statutory law, there is natural law, inscribed in the human heart by the Creator, and therefore, on the basis of natural law, regardless of the wording of Article 18 of the Constitution, I would be against it. Why does the CJEU take on such sensitive issues as family matters? When we joined the EU, we were assured that moral and family matters would be excluded. This is an attempt to interfere in our internal affairs. The CJEU has been usurping powers not granted to it in the treaty for a long time. In fact, it is not just judicial power that it wants to take over, but it is also usurping legislative and executive powers. Tuesday's ruling by the Court of Justice of the European Union may be the first attempt to change Polish law through the back door. In that case, there is nothing to prevent it from trying to do the same in other areas of life where it has no jurisdiction. Now we are supposed to accept same-sex marriages contracted abroad, and soon we will be forced to introduce them in our country, against the will of the majority of Poles. That is the logic of this system. But the CJEU ruling does not directly authorize the violation of the Polish Constitution and other legal acts. It is not as simple as some people think, that it will be possible just to jump over the Constitution and apply the law which, let us add, the CJEU adopted in a manner exceeding its competence. These are matters that do not fall under international regulation. They are matters closely related to the national identity of each state. The eagerness with which the implementation of the ruling has already been declared seems to foreshadow this.